me like a blind man here shortly.
All right, so you're James Loftton?
Yes, ma'am.
And Mr. Loftton was previously in court. Now, the misdemeanor is something that, remind me, why do I have that on?
He was supposed to have pled to his misdemeanor several resets
Right.
ago each time prior to coming down here, because
It's on.
our plan is to have him, we had talked about
To extend
ISF,
probation and ISF.
But now it's for safety if the court considers based on this update PSI, but obviously we can't do that until he pleads to the misdemeanor.
Well, I can do that today, and he can go into custody, and y'all can go
That's what I
take
was
care
just-
of it.
That's what I was just gonna.
Because he'll
say.
sit in custody until he goes and
Correct,
takes
that's-
care of that other case, because he won't go.
correct.
All right. So in cause number 16-24485, first year James Loftton. Mr. Loftton was previously in court, and that is a motion to revoke probation. On probation for the third-degree felony of assault, family violence. It was a 5-year deferred at one point, and then in February of 2020, that probation was revoked and given a 10-year term that was probated for 5 years, so went to a straight probation, placed on high medium caseload and zero tolerance. I've received the updated pre-sentence report also. Has everyone had an opportunity to review?
This is classic defense strategy. Bring in the employer. Highlight stability. Show the judge that the defendant is anchored to something. Judges love stability. But here's the twist. Stability on paper doesn't always override a long violation history. So this move? It's a gamble.
That report?
Yes, ma'am.
I have your own.
Any additions or corrections to that?
No, ma'am, the only thing I would say is since PSI is that we have, this last week, we have gone and taken a drug test of Beaumont Occupational, and my client has, is that, and I have those drug test results if the court would entertain.
I don't, that's not going to change
Okay, fair
what I
enough,
do.
fair
Based
enough.
on the nature of that examination and the substance abuse evaluation, I'm going to follow those. I appreciate that he stayed clean for some amount of time.
Yes, ma'am.
But if I'm going to follow after what I just said with regard to the
Yes,
nature of where we've gone on this, he, looks like there's a new misdemeanor, driving while intoxicated second, and that was from December of 2023. We're just finally getting here, so I'm going to do what's necessary, I think, if I'm going to leave him on probation to keep everybody safe.
Like I said earlier, Judge, Mr. Barrington and I had previously discussed after we both reviewed the PSI that SAFP may very well be
Yeah.
in the best interest of this.
That's what it appears from that evaluation, and so I mean, I rely on them and their
Yes.
evaluation to say
ma'am.
what's best and to, and they're talking about the not just the regular SAFP, but special needs SAFP, so that it covers everything from mental health to drug treatment to everything else that would be necessary, hopefully, for Mr. Loftton to finally be able to complete this probation. In addition, it will be, I will have to, and not just have to, but I will need to extend and plan on extending that probation period as well, because it's up either already or this year, and it's only pending because of the motion. Is that right?
Yes.
Okay. All right. So anything else with regard to that updated report or with me going forward with sentencing?
No, ma'am, other than the fact that he is working, I have his employer here, if you'd like to hear from them. We would ask that, the recommendation initially was ISF, and we would ask the court to consider ISF and sentencing instead, because he has been working with stable employment with his employer for more than 1.5 years now, has had stable housing as far as that goes, and so we feel like that him going to safety would cause, financially devastating for him. And so we would ask that he be allowed to go to ISF and then have more strict monitoring on weekly reporting and weekly drug tests with zero reporting.
Ms. Malfino?
I defer to the first discretion there, but just my review of the PSI, I think safety is probably well-being.
And so with regard to Ms. Jefferson, you initially also agreed that ISF with,
And if you were the defense attorney interviewed too, this right here, this is the judicial equivalent of slamming a gavel without actually slamming it. When a judge says, "I will wonder why I ever gave you this chance," that's a final warning level threat. The tension is real. Question for the audience. Do you think defendants actually change after ultimatums like this? Or does it just delay the inevitable?
Let me.
Being on the high-risk caseload after would be appropriate. Is that your, what are your thoughts?
Yes, that was my initial recommendation. But I also included that I don't know much about his case because he had absconded for, I believe, over 2 years.
Yeah. And it looks like there was a tested positive for methamphetamine August 14th, last month, denied using it, but stated he had used a month ago, but tested positive for it. So I'm trying to see what specifically, why special needs?
I don't believe there was any sort of psychiatric.
I didn't
reason
see that
done.
either,
And
so I'm
that's-
not real
That
sure.
was kind of what, the only question I had about it was.
I don't
is
think we
Special
need-
needs is generally
It is, if there's
more
some
of a
type,
psychological type situation.
we don't have that, so
No, we
it's just
don't.
regular. Okay, so here's what I'm going to do. Mr. Lofton, I am going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I am going to continue you on probation. I'm going to extend your probation period for 3 years. I'm going to order as a condition of your probation that you enter and successfully complete the SAFP program, not the special needs, but the regular SAFP program. And that you'll be on the high medium caseload when you get out. You'll be required to do aftercare. I don't know how to stress strongly enough that this is your last chance. You will not, if you are back in here, I'm going to look at this paper and I'm going to wonder what I did and why. So you will be required to have a drug patch on at all times when you get out. If there's one positive, you're back in here and looking at that 10-year term. You've already agreed to 10 years, no negotiations, no whatever. This is it. You violate, you're getting the 10 years that you agreed to way back when. Do you understand? Yes.
Judge, the only question I have is, I think he was put on probation in 2016, wasn't he? Is that, can we extend for 3 years?
Well, he was put on a deferred in 2016,
Okay.
and then he was revoked and given a straight probation in
Okay.
2020. So actually, I could extend him for 5 more years
Got it.
instead of just 3.
Got it. Fair enough, Your Honor. Thank you.
I'm going to hand you the trial court certification. I need y'all's signature on that, showing that this was an agreement that I followed, and so you've waived your right to appeal. You'll go into custody. Obviously, Mr. Barrington will get it set up as quickly as possible for you to go take care of that other case down the hall in misdemeanor court, because until that's taken care of, you will not be able to go to safety. So y'all need to get that taken care of as quickly as you can.
Yes, sir. Yes, sir.
Thank you for being here. Thank y'all.
May we step over here, Your Honor?
Y'all just sign it real quick right here and they'll take them back. Thanks, Mr. Barrington.
Where's the sign on this? Just right here where it says defendant?
Mm-hmm. Here, I'll give you the, hold on a sec.